Yes. Yeah, welcome to the PGLCET 2022. Karibu sana. Welcome to our class. And now you could read what I posted on the screen. Anyone can unmute and read. Anyone can unmute and read what I posted on the screen. I said anyone can unmute and read what I posted on the screen. Sharat Babu, at least you read it. And I'm sure that you are hearing me. Yes? I'm sure that you are hearing me. Read what I posted on the screen. Sharat Babu, at least you can read, unmute and read. Anyone can unmute and read what I posted
Indian
on the screen.
Constitution and questions.
Yes, because you could not meditate.
Indian Constitution questions.
Namaskar, good evening, assalamu alaikum, vanakkam, Indian Constitution questions, hosted by the Professor Dr. Muhammad Sahib Hussain and Kolikonda Sharat Babu and Mrs. Motamari Sri Vidya, the team. We are three, and here we could see it. Okay, without wasting the time, let me come to our point of study. Could you know that who is that posted on the screen? The photo? Anyone can unmute and give me the answer? Who is the person in the middle to whose photo I posted it? If you know it, you tell me. If you don't know it, you say. If you know it, tell me. If you don't know it, you say pass on. I will give the answer without wasting the time. Quick.
So your voice is not that clear, sir.
No. Yes, now it is clear because of the fluctuation. Is it clear now? Yes. Is it clear now? Because I could see it, because when voice is not reaching or reaching, I could make it out here. Yeah, there is a problem of, yes, now it could hear you. You hear me?
Read the things. What?
I asked the question, the photo which I have shown on the screen, could you know who is that photo in the middle? If you know it, you give me the answer. If you don't know it,
Don't know, sir. Don't know.
He is Keshavananda Bharati.
We don't know, sir.
He is a Keshavananda Bharati. Is it clear?
Yes, I got it, sir. We've read so many cases.
Yes. Okay. The PG last. Okay. Let me continue it. PGLCET 2022 conducted by the University College of Law, Osmania University, and the Constitutional Law and multiple choice question. Number 1 question, be ready. Fundamental rights are defined in which part of the Constitution? A. Part 4, B. Part 3, C. Part 2, D. Part 1. Shoot, which is the correct answer?
Part 2.
Repeat.
C. Part 2.
Wrong.
Part 3, sir, then.
Second option?
Option
Part
B.
3.
Part 3.
Part 3 is the right answer for that question. For the first question, the right answer is Part 3, that is a B option is the correct answer. Okay, second question. One of the fundamental right, that is the right to property, removed from the list of the fundamental rights and converted it into a simple legal right under dash. A. Article 299, B. Article 299 capital A, C. Article 300, D. Article 300 capital A. Shoot, which is the correct answer?
Answer D, sir. Article 300A.
Yes, you are right. It is Article 300 capital A is the right answer for the second question. Now let us see the feedback. In 1978, The 44th Amendment to the Constitution removed the right to property from the list of the fundamental rights and converted it to the simple legal right under the Article 300, capital A. That is the right answer for the second question. The supplementary question, in which amendment it is removed and made into the Article 300A? The answer is supplementary question, 44th Amendment. Then again a supplementary question, 44th Amendment Constitution made in which year? Supplementary question, 1978. Is it clear? Say yes.
Yes, sir.
Yes, sir. When you say yes only, I can go further. And third question, time taken for the drafting the Constitution of India is dash. A, 3 years, 11 days. B, 2 years, 12 days. C, 2 years, 11 months and 18 days. D, 2 years, 1 month
Option C, sir.
and 19 days. Yes.
Option C, sir. 2 years, 11 months, 18 days.
Option C is the right answer. That is the third question. 2 years, 11 months and 80 days. Let me see the feedback here. Making of the Indian Constitution was completed in the year 1949. Supplementary question, 1949, when it is completed. On 26th of the November, supplementary question. By the Constitution Assembly, it took 2 years, 11 months and 18 days to draft and finalize the Constitution of India. Okay, now the fourth question. The word secular, socialist were included or inserted in the Constitution by which dash amendment? That is number A, 44th Amendment, B, 42nd Amendment, C, 73rd Amendment, D, 74th Amendment. Which is the correct answer?
42nd Amendment.
It is the 42nd Amendment. The word secular, socialist and is included or inserted in the Constitution. That is the right answer. The feedback is the 42nd Amendment changed the description of India from a sovereign democratic republic to a sovereign socialist secular democratic republic, and also changed the word unity of the nation to the unity of integrity of the nation. So this is the supplementary question. Unity of the nation will be changed into the unity and integrity of the nation in the 42nd Amendment. Yes. Next question, be ready. Fifth question. Can anyone unmute and read the fifth question? Quick.
Yeah. Who described the preamble of the Constitution as identity card of the Constitution? Option A, Acharya Kripalani. Option B, Jawaharlal Nehru. Option C, Nani Palkhiwala. Option D, Ram Jethmalani. Answer is, sir, Ram Jethmalani.
Wrong.
Preamble Constitution. Palkhiwala, sir. Nani Palkhiwala.
The fifth question, right answer is C, Nani Palkhiwala.
Yes.
Let us see the feedback. N.K. Palkhiwala called the preamble as the identity card of the Constitution. He was an eminent jurist and constitutional expert. He was, of course, he's a taxation expert also. The sixth question. At the beginning of the Constitution, it had how many articles? A, 396, B, 397, C, 399, D, 395. Shoot.
Option D, sir. 395.
It's the 395 is the option, that the D is the right answer for that one. The feedback, let us see. It had a 395 article, 22 parts and 88 schedules at the time of its commencement. Supplementary question, how many parts would be there in the beginning? 22. How many schedule would be there in the beginning? 8 schedule. Of course, the present schedule, how many are there? How many parts are there? It is a supplementary question for you. Is it clear? Say yes.
Yes, sir.
Very good. Seventh question. Preamble is the part of the Constitution was in the case law it is decided. A, in Berberry case law. B, in Golkanath case law. C, in Keshavananda Bharati case law. D, in Shankari Prasad case law.
Option A, sir. Berberry
Option
case.
A, it is a Berberry case. It is said the preamble is the part of the, no, is not the part of the Constitution. Is not part of the
The
Constitution.
answer C is the correct answer in Keshavananda Bharati's.
It is
Answer A,
part
sir,
of the,
sir.
it means answer right is Keshavananda Bharati
Is
case
part
law.
of the constitution is in Keshavananda Bharati's.
Keshavananda
Yes.
Bharati, sir.
Part of the Constitution is Kesavananda Bharati.
You
Not
please
part of
remove
the
that
Constitution is
not.
in Berberry case. Is it clear?
Yes, sir.
Okay. Now let's go to the eighth question. The feedback in which preamble is considered as a part of the constitution. The case law name is Keshavananda Bharati case law. Keshavananda Bharati case law is the Sri Pada Valgaru and other state of Kerala. That is the writ petition civil 135 of. So this is the Keshavananda Bharati landmark decision which is given over there. That it is also said as a fundamental right case law. Keshavananda Bharati case law also be known as a fundamental right case law, or we can also say it's the basic structure doctrine case law. So these are the supplementary questions. So in any way that can be asked. So be ready for that one. So eighth question. Provision relating to the emolument, allowances, privileges, and so on of president is given in which schedule? President, I am speaking. President,
First schedule, sir.
wrong.
Ninth schedule, sir.
The right answer is feedback. You can see. You can say that which is the right answer. The provision relating to the environment, allowances, privileges, so on the President of India and Governor of State, it is given in the right answer is second schedule. The right answer is second schedule. Eighth question, the right answer is D. So the power of the president, pardon, supplementary question. The power of the president, pardon, will be given in Article 72. Article 72 says the president shall have the power to grant pardon, reprieve, respites, or the remissions of punishment, to suspend or remit or commute the sentence of any person convicted of any offense. Supplementary question. Pardon power of the president will be given under the article which? 72. Is it clear? Say yes.
Yes, sir. Yes.
Yes, ninth
Yes,
question.
sir.
Yes.
The provision of a declare emergency was borrowed from the dash. The provision to declare the emergency was borrowed from the dash. A. German Constitution. B. Russian Constitution. C. USA Constitution. D. Australian Constitution.
Option A, sir. German Constitution.
Option A is the right answer for that one. That is the German Constitution is the right answer for that regard. The German Constitution, the emergency provision of the Indian Constitution has been borrowed from the German Constitution. Supplementary question. Under which part of the Constitution of India and from which article to which article the president power is given? Supplementary question. So the emergency provisions contained in the part that is 18th of the Constitution, that is the Roman 18, from the Article 352 360, the provision enable the central government to meet any abnormal situation respectively. Emergency provisions are given over there. But anyway, that Kolikonda's Sarath Babu, be ready for the 10th question. Yes, I am scrolling down. Yes. Continue. Sharath Babu, are you ready?
Yeah, we are ready, sir.
No, I am asking Sharath Babu. Sharath Babu, are you ready or shall I read? Okay, yeah, 10th question. The word constitution is of dash, which is generally used for regulation and orders. Number 8.
Yes, sir, I am ready.
Yeah, but why you are not reading?
A. Latin origin. B. French origin. C. Greek origin. D. German origin.
C. Greek origin.
Wrong.
Latin origins.
It is a
Option
Latin
B, sir.
origin.
French.
But later on, actually it is come from the French origin actually. It is derived from the French origin, but later on from the Latin it made it constitutional. The right answer we should say the first borrowed from that constitution is the French origin is the right answer. But later on it is turned into the constitution. That is the feedback which is given over there. But exact answer is the French origin you have to say. But later on you took it from the Latin origin. So right answer for the 10th question is the B. Okay, next. 11th question.
11th question is, Constitution is not a mere lawyer's document. It is a vehicle of life, and its spirit is always the spirit of age. I unquote. The correct answer, the given answers are A. Acharya Kripalani, B. H.I. H. Kania, C. B.R. Ambedkar, D. S.R. Krishnan.
Sir,
A.
D, answer
Acharya
D, sir.
Kripalani, B. H. Khanna, C. B.R. Ambedkar, D. S.R. Krishna.
Answer is D, sir. S.R. Krishnan.
Wrong.
The correct answer is
B.R.
C.
Ambedkar,
Sir.
sir.
B.R.
B.R. Ambedkar.
The correct answer is C. B.R. Ambedkar. Okay, next question. Proceed.
The 12th question is, who were the dissenting judges in the case of
Keshavananda Bharati case.
Keshavananda Bharati case? A. Sikri De, C. Mukherjee,
Sir,
D.
answer
Yes,
D,
sir.
sir.
Chandrachud.
No.
In Keshavananda
A.
Bharati
Answer
case,
D, sir.
B.
one
Chandrachud.
judge dissented.
Dissented judgment given by the Keshavananda Bharati case is, and option which I has given
So,
is A. Sikri, B. Hegde, C. Mukherjee, D. Chandrachud.
Chandrachud, sir. The
It is
answer is D.
Chandrachud
Yes,
who
sir.
has given the dissenting judgment. And here, the ascending judgments are given by these people. J.J. Shalat, Grover, Mukherjee, Hegde, and Sikri is given the ascending judgment. And the descending judgment were given by the Ray, Palekar, Matthew, Beg, Dwivedi, and Chandrachud. They are the descending judgment. It is given by them. And here he has shown the Keshavananda Bharati. Okay, next. Read. Sharad Babu.
the day of 26th November is celebrated as the Constitution Day every year. Earlier, this day was commemorated as National Law Day. After a resolution by the Supreme Court, Supreme Court Bar Association, a lawyers' body, in A. 1977, B. 1978, C. 1979, D. 1980.
Which year it is changed?
1978, sir. Option B, 1978, sir.
Wrong. Second option.
1980, sir.
Wrong. Third option.
79.
77, sir.
Wrong. The answer is C. That is the 1979. This time nobody has shooted in prompt way. The feedback is in commemoration of the 25th birth anniversary of the Dr. Bhimrao Ambedkar on 26 November in the year 2015. Both the House of the Parliament held a dedicated sitting for the discussion on the commitment to India Constitution as a part of this celebration. Since then, the day of the 26th November celebrated as the Constitution Day every year. Earlier, this was commemorated as a national day after a resolution of the Supreme Court Bar Association lawyers body in 1979. Okay, next question. Read.
Our Constitution is a resolve to constitute India into a dash. Which one is correct? The exact answer: A. Secular, sovereign, socialist, democratic republic. B. Socialist, sovereign, secular, democratic republic. C. Sovereign, socialist, secular, democratic republic. D. Sovereign, secular, socialist, democratic republic. You have to.
Answer C, sir. Sovereign, Socialist, Secular, Democratic
Yes,
Republic.
the correct order is C.
C. Yes, you are
Sovereign,
right.
socialist, secular, democratic republic. C is the correct answer.
Yes, next.
The answer should be in correct order.
Scroll down. Yeah. Next. 15th question.
15th question is, Dr. B.R. Ambedkar very clearly outlined the core expectations underlining the various commitments. It said, our object in framing the Constitution is dash to lay down the form of political democracy and to lay down that our ideal is economic democracy and also prescribe the very government whichever is in power shall strive to bring about economic democracy. A. One-fold, B. Two-fold, C. Threefold, D. Fourfold.
Threefold. Threefold.
Answer is
Fourfold.
B or C or D or A?
C, sir.
Wrong.
Option
D.
D, sir. Fourfold.
Wrong. The right answer is B, twofold. Next question, please. 16th
Find
question.
the odd man out. It means which one is correct sequence and correct statement. A. Indian Constitution lays down a structure for political, economic, and social democracies. B. Constitution of India lays down a structure for political, economic, and social democracies. C. Constitution of India lays down a structure for political, economic, and social democracies. D. Constitution of India lays down a structure for political, economic, and social democracy.
Correct and exact statement.
D, sir.
A, B,
D,
C,
sir.
D.
D.
D, sir.
D is the correct and exact statement. Constitution of India lays down the structure for political, economic, and social democracy. Next, 17th question. Read.
Making India, that is Bharat, as a dash of states, equality before the law and equal protection of the laws is the essence of the Constitution. A. Unionizers. B. Universal. C. Union. D. Federal.
Option
C,
C, sir.
union.
Union.
C, union.
C is the right option. Union is the right option for the 17th question. Next.
It may be also given as that question, sir. India is a union of states. Union of
Yes.
states. Sometimes, along with union territories is also given, but we have to opt for union only. Union of states only.
You have to choose from the 4 options only.
Yes.
Yes, 18th question.
18th question. The Constitution of India is the supreme law of the dash on the basis of which the entire governance system works. A. Country. B. Land. C. India. D. State.
Answer B, sir. Land.
B, sir. Land. Land.
Is the land is the correct answer. Law of the land. Not country, not India, not state. Next, 18th question. 19th question.
The founding dash had chosen parliamentary democracy as the system of governance for the nascent republic. A. Proponents. B. Fathers. C. Stalwarts. D. Legal luminaries.
Proponent, sir.
Wrong.
Option A.
Fathers is the correct answer.
Father is the correct answer. That the B is the correct answer. Next.
Generally, founding is often followed by fathers only.
Yes, true.
The
20th
next question is, who wrote the first copy of the Constitution of India? Prem Behari Narayan Raizada, Behari Prem Narayan Raizada, Naryam Behari Prem Raizada, Raizada Narayan Behari Prem. The first copy of the Constitution of India was written by whom?
B.
Wrong.
Option A, sir.
Option A is the right answer. Prem Bihari Narayan Raizada is the right answer who wrote the first copy of the Constitution of India. Next, 21 question.
Constitution of India promotes dash Indian democracy, parliament system of democracy, parliament system of government, Union of India.
Of India. Union of India.
4 options. A. Indian democracy. B. Parliament system of democracy. C. Parliament system of government. D. Union of India. Which one is the correct answer among the 4?
Option B, sir.
If D is wrong answer.
Option B, sir.
Option B is
Parliament
the right
system
answer.
of democracy.
Parliament system of democracy is the right answer for the 21st question. Next, 22nd question. Continued.
The dash provided some sort of separate legislature in the form of a 12-member legislative council. The Indian Councils Act 1861, which is described as the prime charter of the Indian legislature, inaugurating the system of legislative devolution in India, was followed by the Indian Councils Act of 1892 and 1909. A. Charter Act of 1850. B. Charter Act of 1851. C. Charter Act of 1852. D. Charter Act of 1853.
Option C, sir. Charter Act of 1852.
Wrong.
Option C, sir.
Wrong. The right answer is D. Charter Act of 1853. Next.
The present Constitution of India provides provisions mostly taken from dash. The Government of India Act 1933, the Government of India Act 1934, the Government of India Act 1935, the Government of India Act 1936.
Option C, sir. The Government
Option C
of
is the
India
right
Act
answer.
1950. Yes.
Is that 1935? The most provisions of the present will be taken from the Government India Act of 1935. Government of India Act was passed by the British Parliament in 1935 and it came into effect 1937. It was based on the report of Joint Selection Committee. The most of the provisions are taken from the 1935. Next, 24th question.
The Government of India Act of Dash, which gave effect to the Montagu-Chelmsford reforms, established a bicameral legislature at the Union for the first time and introduced some elements of responsible from government in the provinces. 188, 1886, 1912, 1919, 1935.
1935, sir. D.
That is the correct answer.
No, 1919, sir.
Okay.
1919.
Bicameral. You know what is meant by bicameral?
Twofold.
Yes, sir. What are the twofold?
And both British and Indian.
No. It is
Federal and Union.
No. Both the houses are there. No.
Parliament and
Yes.
Rajya Sabha, Lok Sabha.
Yes, that's called bicameral. That is the system of it is called bicameral. Yes, 25th question.
One of the following comes under directive principles of state policy. A. Right to education. B. Right to work. C. Right to move from one place to the other. D. Right to freedom.
Answer B, sir. Right to work.
Yes, that is
Right.
the correct answer.
The B is the right answer. One of the following comes under the directive principle of state policy is the right to work. That the B is the right answer for the 25th question. Yes, next 26th question.
The article that deals with fundamental duties is A. Article 50A, B. Article 51A, C. Article 53A, D. Article 52.
Answer A, sir. Article 50A.
Wrong.
51A, sir.
That is
The
the
right
correct
answer
answer.
is B, Article
B.
51, capital A.
A.
The right answer for 26th question is B, the Article 51, capital A is the right answer for the 26th question. Next.
The Electoral College is the election of the President of India. In the election of President of India consists of only members of Parliament, B. Only members of Lok Sabha, C. Members of Parliament and MLAs of states, members of Parliament and MLCs and MLAs and
Option-
MLCs of
Members
states.
of Parliament.
Option
A.
A, sir.
A, sir.
A, sir. Only members of Parliament.
Right answer is C,
C.
Option A.
members of
C.
Parliament
MLAs
and
also, but
MLAs of state. That is the right
Okay.
answer for that question. Yes, 28th question.
not MLCs.
Not MLCs.
So 28th question. Attorney General of India is appointed by the Prime Minister, the President, the Chief Justice, Speaker of Lok Sabha.
The President. Option B.
President.
The president will appoint
Yes.
it. Supplementary question. Under which article he can appoint the Attorney General? Supplementary
123.
question.
123, sir.
Even myself also not sure which section will make it out. Okay.
Okay.
Read the 29th question.
Which article deals with formation of new states? A. Article 2, B. Article 3, C. Article 4, D. Article 5.
Option A, sir. Article 2.
Article 3. B is the right option.
Okay.
And which is the latest state in India?
Telangana.
I appreciate. Which year?
2014.
2014.
Which date?
June 2nd.
Okay, I appreciate. Yes, let me read the 30th question. Special status to Kashmir has been abolished by the voting in Parliament on dash. That is A. 3rd August 2019, B. 5th August 2019, C. 6th August 2019, D. 5th August 2020.
Option B,
D,
sir.
sir.
5th August.
D.
Right,
sir,
that's
5th
right.
August.
30th question, right answer is B. That is the 5th August 2019. Next, 31st question. Forests are in the dash. Which list? A. State list. B. Central list. C. Concurrent list. D. Special list.
Central list, sir.
It
Option
is
B.
central list. Forests are in the central list. Next, 32nd
No,
question.
no, sir. It is in the concurrent list, sir.
Concurrent list. Is it not concurrent list?
C is the right answer.
Concurrent list.
Okay.
Concurrent list. C is the right answer.
Mm.
So the question, forest is the C is the right answer. Concurrent list. So 32nd question.
32nd question is, which article authorizes the President to work
Yes.
to seek the opinion of Supreme Court on any question of law? A. Article 144, B. Article 145, C. Article 147, D. Article 143.
Option D, sir. Article 143.
You are right. It is the Article 143 authorize the President to seek the opinion of the Supreme Court on any question of law. Next.
The voting age has been lowered to 18 years from 21 years by A. 62nd Amendment Act 1989, B. 61st Amendment Act 1988, C. 62nd Amendment Act 1988, D. None of the above.
Option A, sir. 1989. 62nd Amendment.
C.
None of the above, sir.
Wrong.
C, sir.
Wrong.
B is the correct answer, sir.
B is the correct
61st.
answer. 61st
61st Amendment Act
1988.
1988.
Where that lowered from
In
the
the
21 years
tenure
to
of
18 years. Next.
the tenure of Rajiv Gandhi's prime ministership.
Yes, you are right.
Yes. Citizenship is dealt by which article of the Constitution of India? A. Article 5 to 10, B. Articles 5 to 12, C. Articles 5 to 7, D. Articles 5 to 11.
C, sir. Article 5 to 7.
Wrong.
D, sir. 5 to 11.
Yes, 5 to 11
Yes.
is right. D is the right. It is dealt citizenship. Next, 35 question.
Educate's record means which is
Record.
the correct one of the following. Only those advocates are entitled to file any matter or document before the Supreme Court. Only these advocates are right to file any matter or document before the Supreme Court. Only these advocates are entitled to file any matter or document below the Supreme Court.
For the
Only these advocates are entitled to file any matter or document before the Supreme Court.
Which one is the correct one? Shoot.
Advocates on record.
A, sir.
A,
Option A.
A, sir. A, sir.
The right answer is
D.
D. Only these advocates are entitled to file any matter or document before the Supreme Court. Feedback, let us see. They can file a appearance also. or act also for any partly in the Supreme Court. Only advocate and record. They can appear or they can act for partly. But when they are filing it, the only those advocates on record would have a right to file in the Supreme Court.
Answer
Okay,
A, na, sir. Only those. Okay.
only these, not only those, only these
Okay.
advocates.
Okay. Okay, sir.
The right wording is only these advocates are entitled to file any matter or document before the Supreme Court. Yes, 36th question, Sharad Babu.
Freedom of press relating to court proceedings. The court held that between freedom of speech and expression also
Extends to
extends to reporting the proceedings that happen in courts, including oral observation made by judges.
in which case line
A.
is decided. A.
Avilal versus State of Madhya Pradesh. B. Lakshmi Bai Chandarji versus State of Karnataka. C. The Chief Election Commissioner of India versus Mr. Vijay Bhaskar. D. The Chief Election Commissioner of India versus Mr. Vinay Bhaskar.
Is a bit tough question.
Answer A, sir.
B, sir.
Option C is the right answer. The Chief Election Commissioner of
Chief
India
Election Commissioner
versus
of India
Mr.
versus
Vijay
Mr.
Bhaskar.
Vijay Bhaskar.
That is the correct answer for that one. Next,
Right to professional education. The court held that though the right to pursue higher education has not been spelled out as a fundamental right under Part 3 of the Constitution, it bears emphasis that the access to professional education is not a government largesse and that the state has an affirmative obligation to facilitate access to the education at all levels. A. Muhammad Salimullah versus Union of India. B. Parzuma Batul versus Union of India. C. Dr. Jayashree Lakshmarao Patil versus the Chief Minister. D. None of the above.
4 option is there. A. Muhammad Salimullah versus Union of India. B. Farzana Batul versus Union of India. C. Dr. Jayashree Lakshman Rao Patil versus Chief Minister. The D. None of the above. It is decided in B. Farzana Batul versus Union of India. Upma is
Sir, I think it should be modified, sir. Upma is.
Yeah, Upma is, full form is A.
No, sir.
Or Unlawful
This
Activity
itself should be
Prevention
modified.
Act. Or B. Initialism and Unlimited Activities Prevention Act.
It is
C. Acronym and United Activity Prevention Act. D.
It should
Acronym
be
and Unlawful
UAPA,
Activities
sir.
Prevention Act. Which one is the
Sir.
correct answer?
That should be UAPA, not Upma.
Yeah, because it is given in the down. I will show you. It is given the army is way where the Upma is given. So here I want to find it. Upma is an acronym or a initialism or what is the full form of Upma? The right answer is it is an acronym and Unlawful Activities Prevention Act. That is the Upma. So here, bail in Upma cases where under trial accused has been subjected to prolonged imprisonment, emphasizing on the right to speedy trial under the Article 21 of the Constitution. The Supreme Court allowed the grant of bail on an accused who had spent over the 5 years in jail as an under trial in case under the Unlawful Activities Prevention Act, UAPA. UAPA, not Upma. UAPA. You are right. UAPA. Then the right answer is
D.
D, sir.
Acronym and Unlawful Activities Prevention Act.
Upma, it is not a UAPA, no, we are versioning. UAPA, when you are making, no, it is wrong. UAPA is a initialism. So here I should say acronym, not the initialism. Initialism.
Initialism and
And
unlawful
Unlawful
activities
Activities
prevention.
Prevention Act is the right, appropriate word here. UAPA. So that is the Unlawful Activities Prevention Act. So in which case law it is decided? Number A, Kerala Union Working Journalists versus Union of India. B, Union of India versus K.A. Najib. C, Union of India versus Siddiqui. D, none of the above.
B, sir.
It's a B, Union of India versus K.A. Najib case law, where the bail in UAPA cases were under trial, accused. Yes, 5 years in jail if they're under trial in case. That's why it is the right answer is Union of India versus K.A. Najib is the right answer. Yes, next 40th question. Read.
Reservation is not a fundamental right. The court held that there is no fundamental right to claim reservation in promotions in public posts. In the case law, A. Mahesh Kumar and another versus State of Uttarakhand and others. B. Mahesh Kumar and another
Yes.
and versus State of Uttaranchal and others. C. Mahesh Kumar and another versus State of Uttarakhand and others. D. None of the above.
Answer is
No idea, sir.
feedback you read.
Mukesh Kumar and another versus State of Uttarakhand and others.
Is it there?
Mukesh, C.
Is it there?
Yes, sir. C.
Check it. Check it.
Mukesh Kumar and
A.
B, sir.
another.
Mukesh Kumar.
C.
Mother.
C is
C.
Mukesh
C
Khanna.
answer C.
The right answer
Mahesh
is
Kumar.
B.
B, sir.
The right answer is none of the above.
Yes,
D.
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 See, the right answer is Mahesh Kumar and another versus State of Uttarakhand and others.
Moreover, there is no state Uttaranchal now.
Yeah.
There is only Uttarakhand.
That's why I gave none of the above. I made wrong. I want to check it. Anyone, you can make it anything. But I found that, yes, none of the above is the right answer. Yes, 41st question.
The
Yes.
judgment in Mukesh Kumar. The
Okay,
judgment in
Mukesh
Mukesh
Kumar and
Kumar
another
and
versus
another
State of Uttarakhand.
and others
Yes.
highlight that dash and dash of the constitution are enabling provisions and that the state governments are not bound to make reservations. The courts have no authority to compel the state governments to do so. A. Article 16 and Article 16(4) capital A. Article 16(4) and Article 16(4). Article 16(4) and Article 16(4)(a) capital. Article 16(4) and Article 16 capital A.
In that case law, it is decided which article is used over there in that case law. The right answer is C. Article 16(4) and Article 16(4) capital A. So next, we'll move to that.
That is, reservations are not a fundamental
Reservations.
right.
Yeah, reservation for the promotion, it cannot insist on the state.
Yes.
Yes. 42nd
Which
question.
is the full form of SSC dash and SSC is dash in the context of women affairs in the Indian Army are entitled to permanent commission. A. Secondary school certificate and initialism, sports school center and acronym, short service commission and acronym, short service commission and initialism.
Option D, sir.
Check it. Yes, you are right, because short service commission SSC, it is not an acronym, it is the initialism. Is it clear?
Yes,
Yes,
sir.
sir.
43rd question.
Secretary Minister of Defense versus Babita Punia, Permanent Commission for Women is Navy and Army. The court ruled that short service commissioned women officers in the Indian Army are entitled to permanent commission and that they have to be considered for PC irrespective of their having exceeded 14 years of service. Denying them PC would be a violation of right to equality under dash, the court held. Article 12, Article 14, Article 19, Article 21.
Option B, sir, Article 14.
Yes, option B is the right
Yes.
answer. Article 14,
Because
equality before the law, equal protection of the law, irrespective of the gender. Next, 44th question.
the Jammu and Kashmir and Ladakh High Court recently held that control over the district judiciary vested in the High Court in dash of the Constitution of India is complete and absolute and provided only to ensure the independence of the judiciary and to achieve effective separation of powers. Article 232, Article 233, Article 234, Article 235.
D, sir, Article 235.
Article 235 is the right answer for the 44th question. You are right. 45th question.
Which is the highest,
Lengthiest.
lengthiest judgment in pages of Supreme Court of India in the case of, is it Keshavanand Bharati case or is it Ayodhya case, Aadhaar card case, that is in Potoswamy case? D is, what is the D, sir? D is not visible.
SP
SP
Gupta
Gupta
case.
case.
Ayodhya case, sir. Ayodhya case.
The lengthiest is the Ayodhya case because now I will make it out. I read this one. 46th question. Match the following part A to the answer part B. Number 1, Keshavananda Bharati case 1973. 2, SP Gupta case 1981. 3, Ayodhya judgment. 4, Aadhaar judgment Potoswamy case. And B side 1045 means 1045 pages, 1048 pages, C 700 pages, D 830 pages. And A 1A 2C 3D 4B, B 1C 2D 3A 4B, and C IB 1B 2C 3A 4D, D 1D 2C 3A 4B. Which is the correct answer?
Option C, sir. Option C.
Yes?
Option C is correct.
Option?
Option B is the correct answer.
Option B is the correct answer because the verdict of the Keshavananda Bharati is a propounded basic structure doctrine 700 pages and SP Gupta 1981 is 830 pages and NJC judgment 2015 142 pages, Aadhaar judgment 2018 in the Potoswamy case 1448, the Ayodhya judgment is 1045 pages. So which one is the highest? Aadhaar judgment Potoswamy case law 2008 is the lengthiest. Yes, lengthiest
Judgment.
lengthiest judgment over there. And how many judges are there in the Keshavananda Bharati case law? Supplementary
sir.
question.
7, sir.
Wrong. In Keshavananda Bharati case law, how many judges sat and they gave the judgment?
3, sir.
Wrong. It's there.
Then 5.
Wrong. How many judges sitting in deciding the Keshavananda Bharati? I know the answer, but I want to show you proof. Keshavananda
9,
Bharati
sir.
Bharati case law. I want to show the proof. That's why I typed this one.
Yes, sir.
Yes.
13 judges.
13 judges, the case was heard by the largest ever constitution bench. The bench gave 11 separate judgments with agreed to some points and differed on other. Nanabhai Palkiwala, assisted by Fali Norman and Soli Sorabji, present the case against the government in both the cases. So that is the Keshavananda Bharati case law, also be known as I told already.
That is a preamble case. That
Okay,
is a
number one, preamble is a part of the constitution is decided in the Keshavananda Bharati case law. Number two, supplementary question.
Fundamental, sir.
Fundamental right
rights.
case law. Number three, I told already.
Directive principles.
No.
Okay.
Another point. Supplementary question. Basic structure case law.
Oh, yes, sir.
So these three things you should have to remember when you want to Keshavananda Bharati case law. Do you think the Keshavananda Bharati is alive?
No, he
no,
expired,
sir.
sir.
He died,
Recently, I think.
Recently.
some 3 months or 4 months before. I don't know exactly.
Recently, sir, yes.
Yes,
Yeah, he
recently
died.
only he died.
But he is a very, very intelligent person. His mutt is, Edner Mutt. He is recently passed away. He is best known for his having lent his name to legal action to the lead to the Supreme Court and hearing a case with its largest bench ever, and which resulted in the articulations of the theory of the basic structure of the Constitution, which has become an essential part of how India defines itself. But the road to the verdict and what came after is a complicated, and this piece written by in 2013 for the 40th anniversary of the verdict described that and how this unassuming spiritual leader came into label. He's a spiritual leader from Kerala. Keshavananda Bharati case that Indian students read not only in the verdict delivered 40 years ago on April 24th, 1973, supplementary question. When the verdict is given, the verdict is given in the 1973 and the which month and which year. Month is April and date is 24th, year is 1973. Inescapable important since it set the principle that the Supreme Court in the guardian of the basic structure of the Constitution doctrine beyond attempts of the Parliament to change it. It also confusing since it involved the 13 judges, the largest bench or sit in the Supreme Court, delivering the 11 verdicts with the fine shades of the differences on all the same day. So the largest bench, the verdict is Keshavananda Bharati case law. Most unfairly, all there is the massive name, His Holiness Keshavananda Bharati, Sri Pada Galvaru versus State of Kerala. Suppose sometime they will ask Keshavananda Bharati, full title of the case law is supplementary question. Read Keshavananda Bharati, Sri Pada Galvaru, State of Kerala, which even a shorter form of sorely taxed hands racing to finish the legal exams paper. Why earth? Some students must have wondered, could not Nani Palkiwala has chosen a case with a shorter name on which case this great contest between the judiciary and the parliament, or more accurately, parliament as a dominated by the government of the Mrs. Indira Gandhi at the time. Okay, so I am giving the feedback because we have the time to lead, and hence this is an additional things which I am giving to you. So His Holiness ever had much to do with, he was and still is head of the Edner Mutt at Kasaragod district. The Mutt is Edner Mutt and Kasaragod district. The law students should consider what they were spared since his full name Sri Mad Jagadguru Sri Shankaracharya Thotakacharya, I don't know how to pronounce, Thotakacharya Keshavananda Bharati Sri Pada Galavaru. That is the full of.
Sri Padan Galavaru.
Yeah. Read. Sharad Babu, read the Srimad Jagadguru.
Sri Keshavananda Bharati Sri Padan Galavaru.
No, Srimad Jagadguru Sri Shankaracharya Thotakacharya Keshavananda Bharati Sri Padan Galvaru. It is the full name of
Srimad
Keshavananda Bharati.
Srimad Jagadguru Sri Sri Sankaracharya Totakacharya Keshavananda Bharati Sri Padan Galavaru.
Yeah, that is the full name of
Sri
the,
Padan Galavaru.
yeah, that is the full title of the Keshavananda Bharati. In March 1970, he filed the case. He filed the case, but his judgment is given in the 1973. Was case challenging the Kerala government attempts to take over mud property. Actual dispute is they would like to take the mud property. The case came into the attention of the Nani Palkiwala, possibly the most eminent advocate in the country at the time, and who decades there might be good case in which to challenge the parliamentary power to amend the constitution at will, including over the property right matters. And he is. So that is what is the dispute in the Keshavananda Bharati?
So his property was confiscated by the state.
What property?
Mud
Mud
property.
property. The mud property
So
was
that was
entire
challenged
mud
by
property
him.
was confiscated by the state of Kerala, and that he challenged the Union of India. And of course,
So
challenge.
till then, the right of property was there as a fundamental right.
Yes.
And then I think in the 42nd Amendment, it was
Yeah,
removed.
it is taken away. It is made into the ordinary
Legal right.
right under the article
300A.
300 capital A.
Eh,
So that was the thing.
It is only a constitutional right or legal right, but it is not a fundamental right.
Yes,
You can fight for the compensation
yes,
of the taken over property,
yes.
but we cannot object to the right of taking property from us.
What are the Golaknath case says? The decision in the Golaknath versus State of Punjab case, which held that Parliament could not amend the fundamental rights guaranteed in the Constitution. That is the Golaknath case, including the right to property. But later on, of course, it is removed. This did not sit well with the Mrs. Indira Gandhi government, dominated by the ex-communists like the Mohan Kumaramangalam, and who saw the right to property to a barrier to land reforms and acquisition, and the court, it is conservative guardian. Parliament passed the 24th, 25th and 29th amendments, allowing the amendment of the fundamental rights and putting some property issues beyond the scope of the judicial review. But later on, in the 42nd amendment, is it the 42nd amendment is removed?
Yes.
What is the famous for 44th amendment? Even 44th amendment also famous.
44th, 1978, sir.
Yeah, that is also famous.
Yes. It is actually it is the correct one. 44th Amendment.
44th amendment.
Yes.
Yeah,
Yes, sir.
of course. In all the amendment, which is the complicated amendment,
The 42nd Amendment.
the complicated
42nd.
amendment is 42nd amendment is a complicated amendment. Supplementary question.
Because at the time, secular and socialist, both words were included in them.
Yes. It's a Mrs. Gandhi period.
Yeah.
So here it is a change. This then was the real stake with the Keshavananda and the start. The arts and looked stark against the court, which was led by the Chief Justice India CJI at the time, SM Sikri. CJI is the Sikri, and he has given the assenting judgment. And only 3 judges have given the dissenting judgment. One of among them is Chandrachud also there, YV Chandrachud. So these are the 11 judges are there in the Golaknath case. 11 judges, but 13 judges are there in the Keshavananda Bharati case, which is the largest constitutional bench. The 13 judges. So that is a very, very remarkable. Hence, we should not forget the Keshavananda Bharati, because he shook the India and he made the place in the India world map also.
A law student must be familiar with all his cases.
No. One should have to familiar. One should have to familiar with all the thing, with that one. So Keshavananda took place in an extraordinary atmosphere of the normally sedate court, a surcharged atmosphere of tension between the court and the government likes which had not been witnessed previously. Reich senior counsel T.R. Andhya Rujina, in his recent account of the case, based on diaries kept with while working with the HMCY, is the constitutional founder. The government legal team is not happy tandem with the writer, the Niren D, the Attorney General, who was the government, blamed its earlier losses in the court. Anyway, this is the thing which I want to share with you. And the now time is, of course, the time is up now. And I don't know, you do got the Cisco WebEx, they did not close it. Perhaps they have given some more time for our students to deal it because the time is up already. Is it or not?
1 hour 5 minutes. Yeah, 1 hour 5 minutes. So
Yes, because it is only 50 minutes. I think the God is grace enough for the student because I am dealing with PGLCET-2022. So that's why mercy on us, and it is not closed. Otherwise, only 50 minutes is there to close it. But anyway, let me stop it. Again, I told you that we are the three in the team. And of course, I introduced Kolikonda Sharad Babu now, but after some time, Motamari Sri Vidya also will come. And these are the teams and whose WhatsApp number I have given over there. If any feedback, that your feedback about our PGLCET-2022 online virtual classes is immense value. Virtual help to us to improve our virtual classes. Please send in WhatsApp your opinion, virtual comments, virtual views without any fear and favor. We are very much thankful to, plus indebted to you all, the participant, for your observation, because your observation make us to deliver a good type of the online classes to you, because we don't feel that because if anybody points out to us, it means that he is clearing our mistakes only. So we will take it and accept it in a positive way and a spirit, in spirit and sportive manner. We will receive your comments and you can send to us either to me or to the Sri Kolikanda Sarath Babu or the Motamari Sri Vidya also. With this, I would like to conclude my today's class. Thank you very much for participation. And if anyone would be there, please take the screenshot now and then, at least to see that how many present among the today's class. If you could take the screenshot, please share with me also. And take the screenshot at the time when the members are more. Is it clear?
yes, sir. Thank you, sir.
And you can post in the WhatsApp group so that we could know. Even one student also benefited by our mission. We feel that our mission is fulfilled, because I told you that I believe that Anni Danamula Kanna.
Vidyadanam minna.
విద్యాదానము మిన్న.
Yes, that I believe in English.
All arms, the educational miss.
At
The greatest one.
At Zenith. Okay. So now I would like to play my curtain riser so that you could see it. So now you have seen my curtain riser. Now I would like to wind up. Thank you very much for today's participation. And tomorrow
Thank you, sir.
meet in the same timings and the same way.
Thank you, sir.
Unless until there
And
is
good night, sir.
any change would be there, I will inform you in advance if any change will happen over there. And goodbye. Asante sana.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता। पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा। विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा। तव शुभ नामे जागे तव शुभ आशीष मांगे, गाहे तव जय गाथा। जन गण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।
We live in a world full